Plaintiffs are finding new ways to have their cake and to eat it too. That is to retain settlement proceeds and then to sue for more. How are they doing it? They're alleging misrepresentation or suppression of material information, especially where court approval is involved, and plaintiffs will argue that the court was misled. Our network chair and Birmingham trial attorney Lee Hollis with Lightfoot Franklin will show you how to sweat the details to achieve bulletproof settlements that avoid 2 bites at the apple. Please welcome Lee Hollis.
Hello again. This is a cautionary tale, for lack of a better term. I'm going to tell a little bit of a story about a case that we had that I didn't appreciate, and I don't think our client did, and I think a lot of practitioners don't appreciate how settlements can be attacked. We don't see it happen that often, and that's what I want to talk a little bit about. So to set this up, your case settles, you've done the hard work, you've negotiated the deal, you're happy with the deal. You let others put it to bed. Somebody else prepares a settlement agreement, no big deal. There's a fairness hearing or an approval hearing by the judge if it's a minor or an incompetent. But we all get into, that's kind of rote. We'll let somebody younger handle that. Let our co-counsel handle that. Well, that might not be a good idea. So say we've got a hypothetical case. I'll try not to get too detailed about our case, but you've got large monetary damages they're claiming, okay? Huge damages, prospect of an early settlement. You see it all the time. Plaintiffs' lawyers want to talk turkey early. They don't do full discovery. There's some informal exchange of information, maybe a little preliminary discovery done. The defense lawyers have investigated the case. They know information, but they obviously don't share it all if they don't ask. Don't ask, don't tell, maybe. So the plaintiff's lawyers maybe don't have all the information. They might be under a misapprehension of some facts, but you get it settled early, go get it done, right? So, and settlement gets reached. There's a fairness hearing. And at the fairness hearing, where the judge has to approve the settlement, the plaintiffs are being the proponents of the settlement, and they make a statement to the court about the case and why they should approve the settlement that's not accurate. The defense lawyers sit there silently. We see this happen a lot. Plaintiffs have settled the case. They got to get it approved. They want to get the money to their clients. They want to get their fee. They submit all the paperwork to approve the settlement. They do most, if not all, the talking at the hearing. So in this scenario, the defense lawyers sit there. You don't really know. You can't get in their heads. Were they listening? Did they hear the misstatement or not? But the case goes on through. The judge settles it in part because of what he's told at the hearing. So the settlement gets done, pennies on the dollar, big securities class action say. The case is dismissed with prejudice, full releases. Everybody thinks, okay, we've got this thing put to bed, money's paid, claims are made by the class, checks are cut, it's all done. So the defendants in certain related litigation are now handling those cases. They take certain positions in this related litigation that they would never have taken if the underlying case is still alive, because it would have hurt their chances there. But hey, that's put to bed, we're released. We got a dismissal with prejudice. We're going to go on and have these other cases and take these positions that serve our interests now. They admit under oath, and actually assert under oath for various strange reasons, that there was underlying liability in the other case that settled for pennies on the dollar, that the underlying damages were on the order of what was being claimed in the underlying case, hundreds of millions of dollars, and they admit that certain key information wasn't disclosed. And they didn't want the other side to know because it would have driven up the cost of settlement. And that's all sworn testimony. So, a new set of plaintiffs' lawyers show up. They file a complaint that lays that story out. Attached to the complaint are sworn deposition testimony establishing, hey, the first case, there was liability. The damages were hundreds of millions of dollars. We got pennies on the dollar. They admit they didn't want us to know this information, and if we had known it, we would never have settled for pennies on the dollar. Pretty good case. Gets everybody's attention. You've got perfectly innocent class members who didn't do anything wrong. They made the claim for whatever money, the settlement pool that was available. So there's a desire to help the innocent plaintiffs. You've got a court that's outraged that it was misled and given false information to approve this settlement. The prior plaintiff lawyers are long gone, and a lot of the witnesses have moved on or died, and you've got to defend that case. So, you think, how can you really do this? You've got a release, a dismissal with prejudice. How can you do this? Well, there are three basic theories or ways that plaintiffs' lawyers can try to do this. An action under Rule 60B, an action for fraud on the court, or independent action for fraud and suppression in the settlement. We'll talk about each one. So we're all familiar with Rule 60B. You can file for a motion for relief from the judgment, and one of the grounds for that is fraud. This tends to be fraud involving the parties. So you can say, hey, court, set aside that judgment you entered because there was fraud involved. But the timing is a big issue there. Under the federal rule, it has to be brought within no more than a year after the entry of the judgment. So in our case, this was brought more than a year after that avenue wasn't really available. But if they come within a year, that is available. Some of the result of that, if you go that route, you reopen the case, and you basically would give the money back. And then you have the case go forward just like it didn't ever settle before on the underlying case. And of course, there could be sanctions if there was wrongful conduct in the prior case. Potential defenses to this type of case, I mentioned that 1-year time limit. Rule 60B is pretty limited on the types of things you can use that for, so you got to make sure it fits under Rule 60B. And there's a pretty high bar for Rule 60B cases in general, so those would be the kind of defenses that you would look at there. The second vehicle available to plaintiffs is Rule 60D, that's more the general powers of the court to set aside a judgment for fraud on the court, as opposed to a fraud on a party. Under Rule 60D3, there's no time limit in the federal rule. So they don't have that 1 year. They can come in any time for a fraud on the court. It's within the inherent power of the trial court that, again, you would set aside the judgment. So that's reopen the case, return the money, and kind of start over. And again, you could have sanctions if the court finds that it was misled. Potential defenses to that avenue. Some states have a time limit to that rule, but not the federal. You could have a laches if people sat on their hands for too long. A big issue in our case was ethical breaches don't give rise to a private cause of action. So the question in that case initially was the defense lawyer sitting in that courtroom who doesn't speak when the misstatement is made by opposing counsel to correct the record. Does he or she have a duty of candor to the court to speak? And that really was a hotly litigated issue. We had a lot of ethical experts on that. But even so, at the end of the day, if a lawyer breaches their ethical duty, that doesn't give rise to a private cause of action. So there has to be more to it than that. These are also difficult to prove. Courts generally say there's a high burden. And it tends to require fraud on the court itself. You can't just go, hey, I was misled, I wouldn't have cut that deal. You have to show the court was misled. And that's typically limited to very egregious cases. But if you don't have some misrepresentation to the court, that's going to be a problem. The third avenue is under Rule 60D to entertain an independent action. And this, in our case, is where they ended up traveling. So, what happens in this scenario? It's an entirely new lawsuit. You're not reopening the old case and litigating the old case. The settlement is affirmed and they sue for the difference in value. That's the kicker. So our case may be settled for $50–60 million range. They say, we're keeping the $50 or $60 million, and the real damages were hundreds of million, close to $1 billion. We just take the difference. That's a pretty dangerous case. Plus, because it's a fraud on the court, they say, and a fraud on us, punitive damages on top of that, so you might be able to get 3 times that. It's a real multiplier. The other difference about this, because you're not litigating the underlying case necessarily, big issues are, what did the lawyers know? When did they know it? What did the class members know? What should people have known? What information was out there that put them on notice of this information? Were they on inquiry notice? So all those things come into play. So in our case, we were getting into the complete files of the plaintiff's lawyers and different competing groups of plaintiff's lawyers and what they were saying to each other, and discovering the complete files and time records of the defense lawyers and what were they saying to whom and when and what did they know. And that gets ugly. Nobody wants all of that seeing the light of day. So under this most dangerous avenue, not only can they keep the money and sue for more, they can get punitive damages and they get into all the lawyers' files. The measure of damages under this, as I said, under this scenario is the difference in what the case would have settled for had the true facts been known. So in our case, we had experts come in and say, okay, take your garden variety case. If the facts are A, B, C, the reasonable settlement value is in this range. But if I had known about more insurance or more assets available or more hidden memos that weren't produced or whatever, if I had known that, the settlement value would have been up here. And that's what the damages part of the case is about. Potential defenses to this avenue are the statute of limitations or statute of repose. I mentioned, what did they know? When should they have known? Were they on inquiry notice? Things like that were big issues in our case. Another legal issue is, a lot of times these would fit under Rule 60B with that 1-year time limit, and the courts are pretty good at looking at that and saying, hey, this is really a Rule 60B issue, and you missed the time. We're not going to let you do an end run around that. So that's an issue to look at. They're also difficult to prove. This is a very narrow, rare exception to be able to keep the money and sue for more, right? But like we all know, bad facts make bad law. And whenever you have an egregious situation of the court feeling like it was misled and innocent class members and what they perceive to be really bad wrongdoing, they're going to find a way to allow this to happen. A quick mention of malpractice issues, because in our case, there was a copycat case filed immediately by another plaintiff's firm that said, yeah, maybe they were misled and there was fraud in the settlement, but I'm also going to name as defendants the plaintiff's lawyers from the original class, because maybe they just didn't do their due diligence. Maybe they didn't do discovery. So either the lawyers are guilty of malpractice for not finding the information out, or they were misled. I win either way, which is pretty good theory. The problem was we have a 2-year, I believe, statute of repose for legal malpractice claims, and so that avenue was shut down. Also, that avenue may not be as lucrative. They may not want to pursue that avenue. So that depends on how much insurance the plaintiff's lawyers have. And, like I mentioned, there's strict time limitations. So, how do you prevent this? As usual, the devil's in the details. And what we learned through this process is you've really got to be aware of this possibility when you're handling the case. Discovery responses. A big issue in our case was supplementation or lack thereof. There were some preliminary discovery responses given that were true at the time, but later the information stated in there was no longer accurate. And we know under the rules, you generally have a duty to supplement when your answer is no longer true. Well, there was no supplementation made here, so they were allowed to make a big stink about that we knew the situation had changed and didn't supplement the responses. By the way, we weren't involved in the first case. We were just involved in the second case. Statements to the court, I mentioned at the hearing, inaccurate statements made by the plaintiff's counsel. And I know people go to those fairness hearings or approval hearings, and it's almost rote. You may not even pay much attention, right? Because it's, hey, done deal. It's their job to push it across the finish line. Pay attention. Listen. Is what they're saying to the court accurate? Because if not, you need to look and see, what should I do? Should I stand up right now and correct the record? Should I talk to the plaintiff's lawyer and point it out to him or her and get them to straighten it out? Do I need to send a letter to clarify something? Do I need to make a supplemental filing to clarify something? So the record is clear that the court had accurate information. And just general honesty to the other side. Sometimes people get too cute, right? We see it all the time. Getting too cute in discovery responses, too cute. Well, they didn't really ask for this, right? And that kind of stuff comes back to burn you, because especially if you got a bad set of facts and the court is pissed at you from the start when they read that complaint, you're not going to catch a break on an interpretation thing like that. So make sure your discovery responses are accurate. Make sure you have produced what you're supposed to produce, because they could come back anytime and say, well, you didn't give me accurate information, you suppressed accurate information, and that's led to the settlement that I wouldn't have agreed to otherwise. So the settlement documents then become key. Again, this is often forms that are getting just change the names. It's often rote kind of stuff that's often passed off to other folks. And that's one of the things that happened here. I'll back up there for a second. The plaintiff lawyers had sent kind of, not quite underling, isn't the quite word, but it wasn't the lead lawyer who negotiated the deal for the plaintiffs was not in the courtroom. And it was one of the co-counsel a little bit lower down the food chain who was in the courtroom for the final fairness hearing, and became a big issue. What did they know? We think this person who negotiated the deal knew, but this person didn't know. So did they know if they were speaking inaccurately or not? And then a lot of the defense lawyers that were sent to that hearing were a little clueless. We don't think they knew some of the information, but the higher-ups who weren't in the courtroom did. So you need to have people there who know what's going on. And in the documents, be involved in the drafting. Like I said, normally it's not uncommon to have the plaintiff's lawyers draft the motion to approve the settlement and submit everything in the brief and support, etc. You need to be involved. You need to look at that and make sure it's accurate. When we went back in this case, some of the statements in there were not accurate. And the judge, it's all in the record, and the judge is basing his or her opinion on what was said and what was submitted. So you got to make sure that's accurate. Obviously, make sure you've got the broadest release possible that releases all types of claims. There were some issues with the wording of this release. Court found it didn't cover this type of claim. You need good no reliance language. I'm not relying on what was told to me by the defendants or was not told to me. I've got all the material information I need to make this decision. It's my own decision based upon consultation with counsel, all that type of language, so you don't have a hook in there that I'm relying on what you told me, so if you didn't tell me something, we might undo this. And this became an interesting issue Don't be joint proponents of the settlement. In our case, there was some loose language in some of the first settlement documents when things were submitted to the court, and the court deemed the parties to be joint proponents of the settlement in the original case, and no longer in an adversarial position, and having a duty to the court of candor, such that the court ruled, and this blew our mind, we were responsible for what was submitted by the plaintiffs. We were responsible for what was said by the plaintiffs because we were joint proponents. We were, in essence, in the court's view, co-counsel, submitting this to the court to be approved. So all of a sudden, we didn't draft any of the inaccurate documents. They did, but we're held responsible. We didn't say anything inaccurate to the court. We didn't say anything at all. They did, but we were held responsible for it because we had deep pockets and they wanted to get some relief to the plaintiffs. So, at the end of the day, the takeaways are, follow the text and the spirit of the rules, don't be too cute. Supplement discovery when you need to make sure they're accurate. Pay attention to what's said in court and submitted to the court to make sure it's accurate and nobody can say the court was misled. And focus on the language of the settlement documents to make sure they're airtight and don't just pass it off to somebody younger to do it. Thank you.